Hello, today we'll discuss about the citizenship in Indian Constitution. So this part is one of the important part in Indian Constitution. For every constitution, citizenship is in one important thing. If we go through the Indian Constitution, we will find there are so many terms have been used just to categorize other people. First, the persons. Here we will find that some provisions are applicable only for the persons or to the persons. Suppose Article 14 or right to equality, or suppose Article 21 right to life and personal liberty. Here the person words have been used or person word has been used, whereas some provisions are there which is categorically mentioned for the citizens, and it is very important. Maximum fundamental rights, those are applicable for the citizen only, and citizen can enforce those fundamental rights before the court of law. Apart from that, some important posts like President of India, Governor of India, uh, or Governor of any state, or Chief Justice, judges of the Supreme Court, High Court, all any other constitutional post. Here, the importance of citizen is coming. These posts can be held by only the citizen, and even the right to vote or casting the vote. This right is also available to the citizen. Apart from that, another term is being used, that is the minority or minorities. So that's why all the people of India have been categorized on the basis of person, citizen, and minorities. Minorities, some provision, Article 21 or 9, all of these 30, those are applicable for the minorities. So in this way, citizenship has been defined, and though citizenship has not been defined, but what are the categories of citizen and how citizenship can be acquired, that has been discussed in this part 2 of Indian Constitution from Article 5 to Article 11. Now, if we see all the citizen in India on this as defined in the Article 5 to 11, here those are categorized into four types of citizens are there. Person domiciled in India, or person migrated from Pakistan, or person migrated to Pakistan, or apart from that, person residing outside India, means apart from Pakistan, other part of the India world abroad. So that's why when we see these articles 5 to 11, those are dealing with basically these four types of citizens. Now, if we go to the Article 5, Article 5 is very simple. At the commencement of this constitution, every person who has his domicile in territory of India and who was born in the territory of India, or either whose parents was born in the territory of India, or who has been ordinarily resident in the territory of India for not less than 5 years, immediately preceding such commencement, shall be a citizen of India. Here it is very much clear that citizenship should be acquired only by the domicile and by birth, and whose parents born in the territory descent, or apart from that, who are for the continuously not less than 5 years residing immediately commencement of such constitution. We know this constitution has been commenced at 26 January 1950. So they will be treated as a citizen of India. Now Article 6. Article 6 is telling that notwithstanding anything in the Article 5, in spite of whatever mentioned in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this constitution if, means who has migrated to India, and from where? From Pakistan. So Pakistan to India, whoever is coming, if he or either of his parents or any of his grandparents was born in the India as defined in Government of India Act, originally enacted. We all know that this one of the source of our constitution was the Government of India Act. It was formed 1935, enacted to originally enacted any area, which has been defined in Government of India Act 1935. That means the British India, and if now that part is now in Pakistan. So if their parents or grandparents as any parts of the India as defined in government means with any parts of the British India or any parts as defined in the Government of India Act 1935. And means in addition to that, in case where such person has so migrated before the 19 July 1948, has been ordinary resident to the territory of India since the date of his migration, means after coming here continuously he is living here, after migration he is living here, or in case where such person has so migrated after the 19 July 1948, he has been registered as a citizen by an officer appointed in that behalf by the government of the Dominion of India on the application made by him. Therefore, for such officer, before the commencement of this constitution, any form or manner prescribed by government. Here question is coming that he has been residing here after the migration in India and registered himself as by the officer of Indian government as the registered citizen here, provided that no person shall be registered unless he has been resident in the India for the last 6 months immediately preceding of his appearance. So this is another important part. So in this way, we can see this is the period who has come from Pakistan to India and who has taken the residence here and residing and registered his name. Now, what date is coming? That is on 19 July 1948. Actually, this date is related to the permit system was allowed. That's why immediately after the independence, two states were formed. We know Indian Independence Act 1947. Two territories were formed by British Parliament, one Pakistan, one India. And those people who migrated from Pakistan to this India, this law is applicable only for those people. And their citizenship may be allowed in this way. That is the mention in Article 6. Now come to the next issue, Article 17. If we sorry, Article 7, Article 7. If we see the basic difference between the 6 and 7, both are dealing with the people who have migrated from the Pakistan to India. But see, 7 has given another type of category, that who has migrated earlier, who has migrated from India to Pakistan, and now they have again come to the India. So that's why Article 6 is telling that those people who came from Pakistan to India, and Article 7 is telling two sets of people who went to the Pakistan from India, and who another type of another type of people who went to the Pakistan and again came back to India. And two sets are there. Now, what are the two stages are there? Notwithstanding anything in the Article 5 and 6, a person, just take from here, a person who has after the first day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not deemed to be the citizen of India. It's very clear. Means those person who has left, who has migrated from India to Pakistan after first day of March 47, they are not the citizen of India. They will not be treated as a citizen of India at any cost. Deemed, not only any idea, they will not be treated as a citizen of India. They have lost their citizenship. Now, Another thing is that provided nothing of these articles apply to person who, after having so migrated in the territory now included Pakistan, has returned to territory of India under the permit or for resettlement or permanent return issued by the authority of any law, and every such person shall, for the purpose of clause B of the article C, deemed to be migrated in territory of India on the 19th day of this July 1948. Here question is coming, those person who migrated to Pakistan and has returned territory of India under a permit system of resettlement or permanent return issued by the authority, or, or under authority of any law, and every such person shall be purpose of the clause B of the 6 Article 6 be deemed to be migrated to the territory of India after the 19 July 1948, means that day where permit system was allowed, means that period, means they left but they again came back, but before the 19 date of 1948. Here this article 7 has a retrospective, overriding effect. If there is any conflict with the article 5, article 6, then article 7 has the effect, overriding, means more powerful than the article 5 and 6. It's the overriding effect. That's why not to say anything mentioned in article 5 and 6. If you see the article starts with that. Now come to the article 8. Article 8 is also very simple. It is the those people who are abroad the India, but not Pakistan, means abroad India. Now again we are coming to the particular provision. Notwithstanding anything in Article 5, any person who or either of whose parents or any of whose grandparents was born in India as defined in the Government of India Act as originally enacted, and who is ordinarily residing in any of the country outside India as so defined shall be deemed to be a citizen of India if he has been registered as citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing, on an application made him therefore to such diplomatic consular representative, whether before and after the commencement of constitution, in the form and manner prescribed by the government of the Dominion of India or Government of India. Means simple meaning of this article is that who is ordinarily residing in any country outside India. Here Pakistan word is not mentioned because the article 5, article 6, article 7, those are applicable for the Pakistan and India relations migration, but article 8 is applicable for the other countries abroad, other countries than Pakistan, where ordinarily residing, and if he has been registered as a citizen of India by diplomatic or consular representative of India in the country where he is residing, where he has registered as the citizen of India, then the prescribed manner they can become the citizen of India, what has been prescribed by Government of India in their law and regulation. Now another situation is coming, Article 19. It's also very simple. No person shall be citizen of India by virtue of Article 5 or deemed to be citizen of India by virtue of Article 8, 6 or 8 if he has voluntarily acquired the citizenship of any foreign state. Means Article 5 has told that origin from India, originally who is from India, or Article 6 has given the provision who has acquired the citizenship of India, or Article 8 has given the scope of the foreign citizen who is residing for abroad can become the citizen. But all of these provisions, whatever it has been mentioned, that will act in spite of that if any voluntarily acquired a citizen of any foreign state, automatically he will not be the citizen of India. So no person of the citizen of India who has voluntarily uh, acquired the citizenship of any foreign country can deem not to be a citizen of India by Article 5, by Article 6, or by Article 8. Means who has voluntarily left the Indian citizenship and acquired the foreign citizenship, those for those persons, this Article 5, 6, and 8 are not applicable. This is the base. All of these are the basic thing. Now, if you see that Article 5, 6, 7, 8, even 9, all of these are telling about the provision when situation when Indian Constitution is being framed. At the time of the making of the Indian Constitution, what was the situation and how these people who are already residing, who has left, who has migrated, who are outside India, how their citizenship may be acquired. Now, if we see the 10 here question is coming afterwards. Means after the enforcement of the constitution, or suppose the formation of the Indian country as a new state, now what will be the situation? So every person who is or deemed to be a citizen of India under any of the foregoing provision of this part shall, subject to the provision of any law made by the parliament, continue to be such citizen. What does it mean? Now suppose constitution has come into force. Constitution has been enforced. India got the independence. Constitution has been enforced. Now every person who is and who deemed to be a citizen of India under any of the foregoing provision of this part means part 2, and foregoing provisions mean the 5, 6, this is 10, the 5, 6, 7, 8, 9 part, subject to the provision of any law made by the parliament. Means suppose unless until parliament is making any law, they will be continue to the citizen of India. Means condition is coming here, parliament, those are constitutional provision, later parliament may make the law and they are subject to that law, but unless until there is any kind of provision is being made by the parliament in this law, they will continue to be the citizen of India. So you have to study this article on such perspective. One is the constitution was making on that time. This is the situation. And Article 11. Article 11 is telling that nothing in these foregoing provisions of the of this part shall derogate from the power of the parliament to make any provision with respect to the acquisition and termination of citizen and all the matters related to citizen. Nothing the foregoing provision of this part, nothing of foregoing means before the 11 all the provisions under the article under this part 2 shall derogate from the power to make any provision in this means shall not restrict, shall not submissive the parliament to make law relating to or respect to acquisition and termination of the citizenship and any matter related to citizenship. Means parliament has given the power to make the law relating to the acquisition and termination of citizenship or any matter of the citizenship, and no such provision of the constitution is taking away or not putting any hindrance to the parliament making such a law. So that's why when India was forming, when constitution was making, on that time there was no Indian parliament. Parliament came into force after the enforcement of the constitution and general election, it came in 1952. So that's why uh, on this period, how the citizenship will be governed? A citizenship will be governed by this Citizenship Act. Sorry, this citizenship part of our part 2 of the Indian Constitution. And apart from that, afterwards, Parliament has the power to make the law relating to acquisition, termination, or any of the provision relating to the citizenship. And these constitutional provision is not putting any kind of bar to the Parliament. This is the clear meaning of this particular article. Now, what is that law? So that's why, without studying Citizenship Act 1955, the citizenship will not be able to understand. No one will be able to understand Indian citizenship law. So that's why basic laws have been given by the Constitution. That is the Part 2 and Article 5 to Article 11. But afterwards, how those should be acquired? So that's why, because you have seen in several articles, it has been mentioned as prescribed, as determined, any such manner. Those terms are giving the scope to make the latter law. So what should be prescribed? Not prescribed by the previous latter law, or in a such manner as will be determined by the Parliament or Government of India. So how they will be determined? How those will be determined? Those will be determined by the making of the law, and that law has been made. And 1955, the Citizenship Act has been enacted by the Parliament. This law is not very broad law. This has given the scope, and two things are coming: the loss of the citizenship and the termination of citizenship. These two things are coming. Here, if we see that acquisition of the citizenship, there are some 5 procedures have been mentioned in this act. Means, as you can see, the Constitution has given the provision which is applicable on those situations when Constitution is being demarcating the area where the fundamental rights are applicable, where DPSP are applicable, where Constitution is applicable, to whom those are applicable. Because next part, part 3 is the fundamental rights. So those are applicable for the citizen or the person. So that's why the previous part, it was a duty of the constitution maker, or constitutional framework, constitutional assembly, to determine who are the citizen those period. And after that, Parliament has given the power to make the law, that how that area should be determined, and Parliament has made. And this is the present law of the nation, that is the Citizenship Act 1955, where 5 procedures of the acquisition of citizenship and 3 procedures for termination or the loss of the citizenship are given. Suppose the acquisition of citizenship by birth, by descent, by registration, by naturalization, and by incorporation of territory. Our country has incorporated some territory. Suppose Sikkim, it has been incorporated in India. So who are the citizen of that area? They will be automatically become the citizen of India citizen. So that is the incorporation of territory. Whereas termination means citizenship may be terminated also. It's not forever. So that's why by renunciation, or by termination, or by deprivation, citizenship may be taken away by the state. So all of these are the citizenship provision presently available, or present law of the nation in our Indian Constitution as well as Citizenship Act. And we have to remember, this citizenship is not the subject which is related to the person. Citizenship is a subject which is related to the state itself. All of these provisions are based on, if you see, that 2 basic principles are there in international law. You have to remember that 2 terms are there. One is jus soli, another is jus singunis. So jus soli is telling that citizenship may be acquired by birth, whereas jus singulinis is telling that citizenship may be acquired by descent. So that these 2 principles are the base. This Latin term have been used by the civil law countries as well as common law countries several times, and either of them being applied by these countries. Jus soli is related to soil, so it is right to soil, and those rights which can be acquired by birth. whereas just singularness is telling that the descent that right by blood. If descendants are there, further parents, grandparents were there, automatically they will accord. So citizenship is very important from the political standpoint as well as from the legal standpoint also. Hope this presentation has given you an idea, a transparent idea about the citizenship law in India under Indian Constitution as well as Citizenship Act as well as basic norms and international principles. Thank you.